Okay, welcome. Welcome to the first Fersch LLC webinar. We are hoping to bring webinars to you once a month, titled Lunch and Learn. Today's topic will be presented by each member of the firm, so you'll get to meet each and every one of us. Each of us will be speaking about a different topic related to COVID-19 and divorce and/or family law. I'll be talking about child custody and family law during COVID. Mr. Shane Duffy will be speaking about what actions you can actually take in the court system now that it is closed closed in part, I should say, and open in part. So Mr. Duffy will address that. Ms. Haft will address, I'm getting some technical help here with the slides. Thank you. Ms. Haft will be presenting information on how to modify a child support order, and Ms. Donskoy will present post-nuptial agreements and why they might be relevant during COVID-19. My name is Patricia Fersch. I've been practicing in this area of the law exclusively for over 25 years. I have been throughout my career committed to public service through pro bono work, and I'm very proud to be the co-creator and sponsor of a program that provides pro bono counsel in divorce here in New York County. I also serve on 2 nonprofit boards. I have been designated a super lawyer, I believe, since 2013, and I am an award recipient of both the New York State Women's Bar Association Harriet Cohen Award for pro bono service, as well as the Family Kind Award for being a lawyer in the trenches. My topic is, as I told you, COVID-19 and child custody. And I first want to bring everyone's attention to an article that appeared in the New York Law Journal written by the Honorable Justice Jeffrey Sunshine. For those of you not familiar with Justice Sunshine sits in the Kings County Supreme Court as a matrimonial judge, but he is also the chief matrimonial judge in the state of New York. And so on March 27th, 2020, he wrote an article about parents and how they behave during this pandemic and how that behavior might influence a custody or an ultimate custody determination in the child's case. I'm just going to highlight some of the things that Justice Sunshine mentioned in the article. He asked the question, how is the individual parent behaving in a crisis while the case is pending? How will the parent behave when it was over? And those who think that there is a lack of consequences to not conducting themselves appropriately during this crisis are wrong. Anyone who's interested in the full article by Justice Sunshine, just please email us and we'll be happy to get it to you. I thought it might be helpful if I specifically addressed some cases or situations that I have been dealing with as a lawyer in family law. Before I go any further, I do want to tell you that we are all licensed in the state of New York, and any references we make to the law is a reference to New York law. And the other thing I want to say is that opinions that are offered by any of us are our opinions alone. We are not here to profess or to present the opinions of any bar association, court system, or anything else. These are our opinions regarding the state of the law at this time in COVID-19. So the first situation I want to speak about is a situation where it was a very young child, perhaps 6 months old. I'm referencing now March of this year. The father was very concerned about his ability to communicate with the mother. That reads, not at all. The mother decided to take the child to Pennsylvania where her parents lived. The father was somewhat distraught about this situation and really didn't know what to do. So at that time, there was really very little that could be done in the court system. So first off, because of the age of the child, because of the prior difficulties, my advice to the father was to do the best that he could to see his child as much as possible. And if that required going to Pennsylvania, that's what he should do. Because he worked from home, as we all did at that time, he was able to get an Airbnb in Pennsylvania, and he was able to negotiate time with the mother to see the child. While not optimal, at least he was continuing an ongoing relationship with this very small child. The end of that story is that the parents, through the pandemic, were able to work things out with each other. They both decided to remain in Pennsylvania, and hopefully they will resolve any issues that they have and continue their lives happily without the assistance of the court. In another case, this was an ongoing case in New York County Supreme Court, a divorce. The mother asked if she could take the children out of state. And this is a situation that's come up quite a bit. So here in New York, she's working all day. The children are in school online. She's somewhat alone in the apartment. And as most of you know, any of you who live in apartments here in New York, the idea of being able to take the children out is somewhat an impossibility, especially during the pandemic when we were all being told to stay home and don't go out. So I said, yes, she could. She did, in fact, take the children to Massachusetts, where her brother had a home, and there were other family around to help care for the children while she was working and continue their schoolwork. The father in that case also traveled to Massachusetts, and when he arrived in Massachusetts, I advised the mother to follow the court's order as to custody and visitation. A couple of examples of where I think the behavior during the pandemic was a little bit over the top and done perhaps to gain a custodial advantage. I refer you back to Justice Sunshine's article. I do not think the mother in this case would obtain a custodial advantage. The father one day had to go into work. He took the subway. He wore a mask. Any of you who have been in the subways know that they're relatively empty, and actually, since the cleanup was ordered from 1 to 5 a.m., quite clean. The father, however, was told by the mother that because he took the subway to work, he now had to be quarantined for an additional 2 weeks. The same father was also seen during a FaceTime call. The child made the call to the father, so he wasn't prepared for the call. He was seen sitting at a table with a friend, and he didn't have a mask on. The mother, again, attempted to penalize the father by essentially advising him he couldn't see the child because he had done this. I think that should this case go on to trial, which it may very well, the actions of this mother speak to how this mother will behave, not just during a pandemic, but during life and her regard for the relationship between the father and the child. In another case, a stepmother who, and this is also pretty common, we have two different families. We have the bio father and the bio mother each have moved on in their relationships and had children with other partners. And one of those partners is now concerned that when the child in common of the original couple comes into their home, the other side hasn't been following, obeying the protocols as to COVID-19 and what you need to do to keep yourself and your child safe. I think that here the stepmother was overreaching in that she wanted to essentially suspend the parenting time between her husband and his child with the other woman. I think it's reasonable for people to speak to each other, to communicate what safeguards they're taking, how they want to address the child being outside and playing with other families, social distancing, mask wearing, etc. But to suspend access, I think, is extreme. Supervised visitation during COVID-19, I've been asked about this. I learned it was available. I had a lengthy conversation with an organization that provides supervised visitation, CFS. Many of you may have heard of it, Comprehensive Family Services. They were providing social workers to go to the parent's home and provide supervised visitation. The mother in the case who I represented was really uncomfortable with this, and frankly, I did not disagree. We had no idea where the social worker may have been, where they live, who they live with. While I would expect as a professional and working for a professional organization, they would take all precautions. I don't think it was unreasonable to say, I don't want supervised visitation during COVID. I agree to supervised online access. And finally, we filed a contempt motion with regard to one of our clients during COVID. And the purpose, among other things, of the contempt motion, I'll point out that this was an ongoing case, and it was after the judges had returned to court regarding the father's parenting time, and the mother had not been allowing it. In this case, the court immediately ordered that the children be produced for the father, but the mother had created a situation with the children that they were essentially scared to leave the apartment because the mother had made them so afraid of COVID. In this case, we asked for, and the court ordered, a supervisor from the same agency, CFS, to come and supervise the transfer of the children to the father. That actually worked, and the father has been seeing the children ever since. So we're very pleased, at least at this time, with that result. I'm going to now turn my chair over to the next presenter, which is Mr. Shane Duffy, Associate Attorney with our office. I do want to point out one little detail about Mr. Duffy. He was actually sworn in to the bar during COVID-19 virtually.
Good afternoon, everybody. Thank you for joining us today. So my name is Shane Duffy. I'm an associate attorney here at Fersch LLC. I've been working here since May of 2017, where I started as a student intern during law school. There's me. So I've been working here since May 2017, and I passed the bar last July, and as Ms. Fersch noted, I was virtually sworn in just this past June. So brings us to my topic. I'm going to be talking about the functionality of the unified court system during COVID-19. So the pandemic has impacted all of our daily lives, changed everybody's routine, and turned the world upside down. And unfortunately, our court system here in New York State is no exception to the rule. And trying to navigate the court system right now for families and litigants poses a number of challenges. I'm going to try and go through them today for you. So the third week of March, when COVID started picking up here in New York City, our court system kind of ground to a halt. All in-person matters were suspended indefinitely. And the Supreme Court, for a time, only heard essential applications until April 13th. During that time, the Supreme Court was only hearing temporary orders of protection and then any other emergency applications for the that related to the coronavirus, rather. But as of July 7th, New York City's courts have entered phase 3 of reopening, which means that judges are back in their chambers, but in-person matters are still suspended, except for a small number of criminal complaints in the criminal courts where they're hearing felony cases. Outside of New York City, there are some in-person matters resuming, but again, we're still waiting on any date and timeline here in the city. We get an update every week or so regarding the status of reopening of the full court system here, and rather the Supreme Court, but there's no real deadline for when they'll resume their full functionality or when all in-person matters are going to be able to resume. So the Supreme Court has been reopening slowly, but not fully yet. So now I'll turn to the family court, which is a whole separate matter. So the family courts here in New York City, they shut down around the same time, the third week of March. And since then, news about its reopening and functionality has been scant. Right now, we know that there's 5 virtual courtrooms that will hear these matters listed on the slides. So they'll take and listen to child protection intake cases, newly filed child delinquency intake applications, any family offense petitions seeking an order of protection, and then any other matter that they deem to be an emergency. But the reality with the family courts is that right now, any filing is essentially just going to save your spot in line for when the courts do reopen more fully. It is important that if you are filing in family court, that you not be discouraged by the slow reopening and that you file to preserve any retroactivity of any of your petitions or applications. But it should be noted that of the two, family court, its functionality is still severely limited, and there's really no timeline as to when that's going to get better, unfortunately. So what this means for people involved in current litigation or any prospective litigants is that the court system is operating slower than it normally would. Not that it was breaking light speed before COVID, but right now it's especially important that everybody remain patient and realize that the court is also limited by the COVID-19 restrictions that we're all hampered by, having to remain socially distant, only X number of people are allowed in the office out of the full staff. So while things are moving forward slowly, they are moving forward, so it's important to just try and remain patient. But aside from getting the courts involved, now is the perfect time to try and settle any matter that you are currently involved in. So with the resources tight and the courts moving slowly, it just seems to make more sense to reach out to the other side. We'd be happy to write a lawyer letter to your spouse or co-parent to try and encourage any sort of settlement or negotiation or their counsel regarding the same. So these are some services that are currently available right now. We can help you start a new divorce action. We can help you file any orders to show cause or any motions pursuant thereto in the Supreme Court. In both the Supreme Court and the family court, we can assist in the filing of emergency applications seeking temporary orders of protection. We can help you with child support petitions, enforcement of any judgments of divorce, and the drafting of prenuptial, postnuptial, and separation agreements. Another service that's available directly through the courts is the child support services support collection unit. So at the bottom of the slide here is the application for child support services. So anybody who is seeking the enforcement of a child support order or a judgment of divorce that includes a provision of child support and it isn't being paid can apply and attach whatever order or agreement you have to your application that you can get at that website, and you submit it to whichever borough you're in. They're all listed here where you'd send them in, or you could submit it online at the email address on the left-hand side of the screen. So once you're approved, your application's approved, the support collections unit acts as an intermediary between you and the payer spouse. So what that means is that the payer spouse will pay the support collections unit directly, and they'll hold the money for you, and you'd withdraw your money there from them. They keep a record of all the payments that come in and go out, and they also have the power that if the payer continues to not pay, they can suspend their driver's license, they can suspend professional licenses, they can garnish wages, they could garnish tax returns. So they have a lot of power to enforce right now while court support is kind of lacking. So right now I'm going to introduce our partner, Meryl Haft. She's going to be speaking to you about child support modifications, both upwards and downwards. Thank you for your time.
Good afternoon, everyone. Thank you for joining us. As Shane said, my name is Meryl Haft. I am a partner here at Fersch LLC, and I'm going to be talking about child support modifications and specifically sort of what we're anticipating given the current pandemic. So what I'm going to be addressing is where you already have an existing child support order, either from the family court or as part of a divorce agreement that was incorporated into a judgment of divorce. So a lot of people have been suffering reductions in income, changes to their standard of living, parenting changes, and so you may be wondering, do I have a basis to seek a modification of child support? Well, in the absence of an agreement setting an alternative standard the legal basis in New York to seek a modification of child support is one of these three things on this slide. One, an increase or decrease of either parent's income by 15% or more, or 3 years have passed since the order was last entered or modified, or 3, there has been a substantial change in circumstances. So you may be wondering, what is a substantial change in circumstances? It's sort of a catch-all phrase the courts use, but some common possibilities would be where the child's needs have increased, or the parenting time arrangement has changed since you last agreed to or had a court order the amount of support that you're receiving. But most common, I would say, would be numbers 1 and 2. Those are the most common reasons that people would come back to court and ask for a modification. So I wanted to just touch on how we think COVID-19 will impact child support modifications. Although this has yet to be seen, because as Shane mentioned, the courts are largely closed at this time, we do think that we're going to see an increase in requests for child support modifications based on one or both parents' reduced income. But you should know that job loss alone is not usually sufficient to warrant a downward modification of child support. So the courts are going to first look at your last year's tax return if you are making an application, as well as your current income and any reduction in income that you've had. So keep in mind that if you're seeking a downward modification, the applicant must show that their job loss or income reduction was no fault of their own, and that they have diligently sought commensurate employment. So if you are someone who is paying a child support order and you are considering filing a downward modification, these are some things that you can do now, even before the courts reopen. So number 1, keep a detailed log. The courts will call this a job search diary. So you'll want to record all of the employment that you've sought since the job loss or reduction in income. So all the resumes and cover letters that you've sent out, emails and phone calls that you've made, any networking that you've done, and especially any interviews that you've gone on, whether you've followed up, what was the result of that. You'll definitely want to file a petition as soon as possible, because applications to modify are only retroactive to the date of filing, not the date that you suffered the job loss or the reduction in income. But just sort of a caveat here, as I just mentioned, the courts are going to first look at your last year's reported income. And so you're going to need to show, as I say below here, that you've continued to seek employment and that you've made your best efforts to pay the existing support order as you seek the downward modification. So if you are in the situation where you're considering filing for an upward modification or perhaps enforcement of an existing support order, there's a couple things that you should be thinking about now. Perhaps that you're someone who has lost a job, but you're the recipient of child support, and you're asking that the other parent pay more now based on your job loss. Or perhaps you have found yourself in a situation where your other parent is entering into some lucrative business during COVID, for example, a mask making business, and now your other parent has significantly increased their income. Well, you're going to want to file your modification request as soon as possible to protect retroactivity. And even though it might be several months before your court date would be scheduled, as soon as you get that petition in, that will sort of save your place in line and save the date to which the court will look back when issuing the modification. As for enforcement, now is the time to get organized, keep all of your records of payments received, and for add-on expenses, proofs of expenses and proof of payment. And you're going to want to show that you sought repayment from the payor before coming to court. We're having a little fire drill, so I apologize for any sound you hear in the background. And now I'd like to introduce Maxine Donskoy, who is a partner at our firm as well. And today she's going to be talking to you about post-nuptial agreements.
Good afternoon, everyone. As Meryl said, I am Maxine Donskoy. I'm a partner here at Fersch LLC. I have been with Ms. Fersch since 2012, when I started at Fersch as an associate attorney, and I have been named a Super Lawyer Rising Star since 2014. I'm happy to discuss post-nuptial agreements in a COVID world with you today. The COVID-19 pandemic and the quarantine/working from home environment that has come with it has provided married couples the opportunity to reevaluate their relationships. For some, the pandemic has made their bond stronger. However, for many other couples, the constant closeness has revealed considerable flaws in their relationship. Those traits that maybe you once found cute or funny have now become annoying and obnoxious, such that you can no longer stand being under one roof together. If you and your spouse fall into that latter category, with the pandemic leading you to the realization that your marriage may be ending, divorce is an option, especially if the rest of the world is an indication, since this pandemic and the confinement of spouses may lead to a rise in divorce cases. For example, in China, following the quarantine, there has been an unprecedented rise in divorce rate with an expected similar effect in countries throughout the world, including the United States. However, we want you to know that divorce is not the only option. Another choice, rather than the immediate finality of divorce, is the creation of a post-nuptial agreement. A post-nuptial agreement allows you and your spouse to continue to work on your marriage, but it is intended to provide an agreement on financial terms in the event that the working on the marriage doesn't work out. If the marriage fails, a post-nuptial agreement will ease and expedite the divorce process and save the couple legal fees in as much as they previously resolved financial aspects of the marriage. If the marriage remains intact until a spouse's death, a post-nuptial agreement can help prevent inheritance disputes between a person's surviving spouse and his or her heirs. Now you may be wondering, what exactly is a post-nuptial agreement? Is it like a prenuptial agreement? What could be the difference? A post-nuptial agreement is a contract entered into by and between spouses during the marriage. A prenuptial agreement is an agreement entered by a couple prior to getting married in consideration for the upcoming marriage. So you may be wondering, what could a post-nuptial agreement include? Post-nuptial agreements can include spousal support amounts, if any, and the length of those payments. Spousal support is also known as alimony to some. It can include equitable distribution, the division of property or debt, which includes marital debt, credit card debt, or if you want to delineate separate debt. In addition, it can define what is considered marital and separate property. You and your spouse will be able to specifically identify which assets are separate and which are marital. Because if you do not keep your separate property separate, it could later be commingled and transmuted into marital property. For example, if you each brought a significant amount of assets into the marriage and deposited into a joint account without a prenuptial or postnuptial agreement, those assets or cash, whatever it may be, may then be later considered to be marital property and a gift to the marriage. You could use a postnuptial agreement to protect a large inheritance or personal injury award, which those are generally considered separate property if you receive them during the marriage. However, they must be held separately in order to remain separate property. In relation to COVID-19, the postnuptial agreement can also address the manner in which a couple would respond to a sudden dramatic change in their financial situation, and the manner in which assets will be handled should one spouse pass away, Since you cannot disinherit your spouse, you can both agree to waive the spousal right of election or exclude certain assets from the marital estate. This could be if one spouse has children from a previous relationship and they want to leave certain assets to the children and not to their current spouse. However, a postnuptial agreement cannot and should not include issues relating to children, such as custody, visitation, or child support, as those will need to be resolved at the time of the divorce action, either through a settlement agreement or court involvement. Child-related issues cannot be resolved prior to that because there is a standard of what is in the best interest of the child. Now, you may be wondering, what makes a postnuptial agreement valid? Can my spouse and I just sign a piece of paper that we agree to something? No. The validity of a postnuptial agreement does not require a divorce, so you should know that. It could remain valid even if you remain married. However, it does require full and fair disclosure, meaning you must disclose your assets, your debts, and if you do not do so, it could lead to the agreement being considered invalid. The agreement must be voluntary. You cannot force, coerce, or threaten your spouse into entering into an agreement. Additionally, it must be fair and it cannot be biased. It cannot say that I will maintain everything and keep all of the assets while you get nothing. In addition, it must be signed by both spouses before a notary public and acknowledged as if it were a deed. A postnuptial agreement can provide a number of benefits for both spouses. Not only will it outline what should happen in the case of a divorce or a separation, but an agreement can also take a great deal of pressure from a marriage and give both spouses the confidence to work on their future marriage. However, it's important that you consult with an attorney and discuss what your options are. I'm happy to meet with you or discuss with you over the telephone or over Zoom your different options, and glad to negotiate or draft an agreement on your behalf. At this time, we will not only be taking questions, but Ms. Fersch will also discuss the different types of mediation that could be available to you during this time. And I welcome Ms. Fersch to return back. I will just... Thank you.
Hello again. We want to let you know that there are other options other than the courts to resolve differences, and we have some suggestions on the screen that we make based on our experience with these various individuals and these programs. First of all, there are 4 retired matrimonial judges who are all in private practice, who all offer expert mediation services. We list each of the judges here and their telephone numbers, and so if any of you are interested, they are certainly available through their private law practices to assist in mediation, especially of a divorce. We also list a professional mediator, Ken Newman from the Center for Mediation and Training. Mr. Newman has had considerable success working with various couples, and so we recommend him and his firm. We also recommend highly Family Kind. Full disclosure, I already told you they gave me a service award, I believe in 2018. I also sit on the board of Family Kind, but Family Kind is well known to the court system throughout the 5 boroughs. I particularly recommend the Good Talk program. It helps couples just speak to each other. Don't send e-bombs. Don't, be deflective, but to actually communicate about issues intelligently and professionally regarding your children. They also offer co-parenting webinars. You may find those helpful. They also have mediation services where they'll refer you to a mediator, or they can refer you. They also have a certified by the New York State I believe, Office of Court Administration Parent Education Program. These are helpful even if you're an excellent parent. They help you maybe see things that you're doing that you're not aware that you're doing. So we offer this information really as a guide to other services other than going to court. We will take questions now, and we're going to try to answer as many of the questions as we can as time permits. Those of you, again, who have very personal questions related to specific issues in your cases, might be better to contact us off the program. My colleague, Ms. Donskoy, is going to help me pull up the questions here. So just give us a second and we will take them. I will defer to my colleagues to answer questions related to the topics that they presented. So first question, the question is, and by the way, all questions submitted are anonymous. You don't have to worry that somebody's going to see that you asked the question. The question is, can I file a modification request while the courts are still closed? And if so, can you tell me what the process is currently? So I'm going to defer to my colleague, Merrill Haith, to answer this question, and I'll be back.
So I believe the question refers to a modification of child support rather than a modification of custody. As to child support, yes, you can file the request to modify. The issue is that the petition may not be heard for some time, but we can help you with that and we can get your place in line and protect the retroactivity of that application. There's another question I will read. Can I include some parameters for parenting which restrict the number of people? My co-parent exposes my son, for example, restrict my co-parent from taking our son to high density locations like supermarkets, fast food restaurants, etc. So I will have Ms. Fersch answer that one.
So this is a relatively common problem during COVID. So hopefully, the short answer is yes, you can, but it kind of has to be voluntary. In other words, you and your co-parent have to reach some agreement that you're going to allow the child to play with 1 to 3 children, and that they're known and you've sort of been with this family throughout COVID, so the risk of contracting COVID from any member of this family is very small. Supermarkets gets a little bit trickier. That is essential. And if you're a single parent with a child and you have to go to the supermarket, you're likely to have to take the child with you. Obviously, we need to believe, and this turns into a trust issue, we need to believe that someone is going to act in the best interest of our child and behave appropriately. Fast food restaurants, probably the same thing. Again, if the restaurant is following the COVID restrictions, if they are, requiring that people wear masks, that the tables are set apart, that the lines at the counter are 6 feet, people are forced to stand 6 feet apart, it's probably okay. So, but generally speaking, you need to be sensible about this and fair. The next question is about child support. And it says, I currently have been litigating a child support case with my co-parent and receive a temporary child support payment twice a month. Due to COVID-19, I've been furloughed and now only depend on unemployment. How do I request a modification of the temporary support, the child support temporary judgment to reflect my new lower income? I'm going to give it back to Ms. Haith.
Okay, so I think this question refers to an existing case. So there's a pending petition. In that situation, you would just, whenever your next court appearance may be, you will present proof of the reduction in your income and what the unemployment figures are. So any pending application for child support will take into account any changes that occur between when you have the temporary order now and when there is a final order. So you'll just want to make sure when your case is next heard to bring proof of those changes. I'm sorry, I'll read the next question. Just scroll down. Okay, it says, I plan on applying for a number of private schools for next fall. My co-parent has refused to provide me with the financial documents that are needed for these private school applications. Can I legally compel my co-parent to provide me with the required documents? I mean, I can answer this as well. Essentially, what I would suggest that you would do would be to file a petition regarding payment for that private school, and in that process, the other parent will need to disclose their income. You are going to need that information for that proceeding. So that would be one way I would suggest to get that information. Okay, one more question. With the courts closed or backlogged, what options are available regarding custody disputes as a function of one parent's concern for COVID? And I'll have Ms. Fersch answer that.
Here we get into the situation again of is it an existing case? So I had several existing cases before the court shut down, and so those cases were obviously assigned to judges or referees who were able to hear them. As I believe Mr. Duffy told you, the referees and judges returned to the courtroom. They are physically actually there sometime, I believe, in early June. And so they became available to at least conference those cases. In terms of, disputes, other than conferencing the case with the judge, if you actually need to file a petition and seek relief from the court, the family court, if it's a case that isn't already in the court and assigned to a judge, you can do so. The forms are available online at the court website, newyorkcourts.gov. You have to complete the form, and then there's information as to where to file it. You go into a queue, though, in terms of that case being assigned to a judge, and when that case is actually heard, I have no idea. I can tell you the cases that I filed that prior or at the beginning of COVID still haven't come up. So let me take the next question. What are your thoughts about one parent unilaterally deciding to create a learning part for their child with special needs, which will deprive the service of services? Do the courts favor the professional organization's opinion, i.e. the American Academy of Pediatrics? What resource is available? I'm sorry, the question is, what recourse is there when one parent is demanding a standard of isolation more robust than recommended by public health officials? These are a little tricky to answer here. So let me just give this general answer. If you are a vegan and your co-parent is not a vegan, but when you're living together, you decide to raise the child as a vegan, and then you separate, most likely a court's going to say child should continue on a vegan diet. That's what the child knows. That's what you both agreed that would happen with this particular child's diet. If same thing as to a religion. The courts are also going to look to the norm. So what does this mean? The norm means that, and the American Academy of Pediatrics recommends that all children be vaccinated. That would be the opinion most likely of a court with regard to whether or not to vaccinate. So here, you're sort of asking two questions, and the top of this is unilateral. So unilaterally deciding anything is probably not the way to go. But it sounds like if you have serious concerns that the best interest of this child is not being considered, or it's not in the best interest of this child, you undoubtedly need to file in a court and seek relief. Okay, another question. If I have a full stay away with an order of protection, will it be easier to get full legal custody as we won't be able to make decisions together? The short answer to that question is yes. Obviously, if there is an order of protection in place, meaning that you and the other parent should not have contact. Legal custody would be, which is decision-making for those of you who don't know, here in the state of New York, legal custody refers to decision-making. So yes, that would be, it would be easier for the person holding the order of protection to get sole legal custody. Okay, next question. I think the question is, you're asking, would we produce the slide deck? I believe the answer to that is yes. We're going to have every slide available for everyone, and we're also going to have available a recording of this whole process that we'll make available. Next, another question: how can you prove the spouse has a mental illness if they are undiagnosed? This is an incredibly, well, first let me say this. This is an issue we face all the time. Most people reach a resolution as to all of the issues impacting on their divorce, or if they're not married, on child support and custody. However, when someone has a mental illness, they have a serious addiction, and they're in denial about it, it becomes extremely difficult. So the first way we can detect or determine that someone's got a mental illness is behavior. Same thing applies to a drug addiction or an alcohol addiction. But the other answer is the court can order, if child custody is at issue, they can order a forensic examination by a psychologist or psychiatrist to examine the parties. I will tell you, though, that the forensic examiner cannot make a diagnosis of the person suspected of having the mental illness. So this is a difficult question to deal with in court. I'm going to let Ms. Haft answer the next question. Then there are two here. Consequences for not paying child support for a long time. If he proves he hasn't been making money, close business, is it forgiven? How much time does the judge give to repay? I'll let Ms. Hafe answer.
Okay, so generally speaking, there are several remedies for a parent who's not receiving child support, but there's an existing order. There are the services of the support collection unit, which has various powers to garnish wages, suspend driver's licenses, professional licenses. So getting your account set up with the SCU would be one first step. There's also the possibility of a finding of contempt. Basically, you'd have to prove that the other parent is willfully not paying an existing child support award. If the person can prove that they haven't made money and can show that it's really not their fault, or their non-payment is not willful, this can get a little bit more difficult. You can't find someone in contempt if they have a good reason, that is, they have no income, for not paying child support. The last part of this question was, how much time will a judge give to repay? I mean, if a person's making a good faith effort to make good on an order, to pay something what they're able to, that judge is most likely not going to punish that person. The arrears do not just go away, though. Arrears can be, they can exist essentially indefinitely if it's found that someone owes child support. So if that other parent starts earning money years later, and you have a finding of what they owed, you can collect at that time. Okay. There's a question, is there an update on the eviction moratorium? This is really outside of our area of practice, so I'm going to skip that. Are there any other questions? No?
Oh, wait, there's something in the chat.
Oh,
Um,
we got it.
We have an answer to the question regarding the eviction moratorium. It's been extended to October 1st.
This is from a lawyer that we know, so I think that's pretty credible. Okay. Here's one more question. If a custody order was delayed, do parents remain in a holding pattern to wait for new court dates? I'll have Ms. Fersch answer that.
Before I answer this question, I want to add to the answer that Ms. Hafe gave regarding child support. I just want to make it very clear that if there's an existing order and it hasn't been modified downward, whatever the amount in the existing order was or is, that will continue until the court modifies it or the person seeking the modification asked for it. The second thing is there's only one person who can waive arrears. So if it's determined that a payee is owed $100,000 by the payor, the only person who can waive those arrears is the payee. The court cannot do it. They have no legal authority to say, oh, well, you know, he lost his business, so therefore you should make him pay. So I just wanted to make that clear. So if it's delayed, yeah, the answer is yes. You remain in a holding pattern, the case until the court actually comes up in some queue, or alternatively, the case in the case person that's asking, I believe her case was assigned to a referee, and so if she wants to quickly move it ahead, I could contact the referee and see if we can get an advance on a court date. If there are no further questions, we're going to close it out now. We're happy to answer questions, though. If you reach out to us, we certainly will be happy to do so. I do want to say that, as I said in the very beginning, we intend to continue this. We will be on different topics asking experts to join us. So the next webinar that we're going to present is on September 23rd. Again, the time is 1 to 2 p.m. That webinar is going to be on what to expect from a forensic exam. By forensic exam, I'm referring to in a custody case and when the court has ordered a psychologist or psychiatrist to examine you, your spouse, or the other parent, and your children. So Dr. Paul Heimowitz is going to join us. Dr. Heimowitz is a PhD forensic examiner who handles cases in the family and Supreme Courts in all of the 5 boroughs. We're very happy that he agreed to give to do part of the presentation with us. Thereafter, in October, date to be announced, we're going to address toxic divorces. What can you do when you find yourself in that kind of a situation? I think that's all for us now, unless I'm to answer another question. It appears I'm not. So we thank you so much for joining us. This has been great, really great for us. We hope you've learned some things from it. And if we can be of help, please don't hesitate to ask. Thanks and have a good day. Be safe, everyone. Please take care of yourselves and your families.